Hello friends, Namaskaram, how are you? Sometimes it is seen that the demand is not specific concerning the prevention of corruption at case. But despite of that, we are prosecuted concerning the case under Prevention of Corruption Act. So if you are falsely booked and there is no specific demand, what we can do and what will be our strategy regarding this, I have taken the present class and I will specify you the things in the easier way so that you could easily observe your case, and if there is any deficiency or any discrepancy, you could easily find out the same and could work out accordingly. So directly we are moving on the board. As we know that in anti-corruption case, demand is must. If demand is not proved, even though recovery and acceptance is proved, then accused could have the benefit. Number two, demand must be specific, it must be clear, and reasonable conclusions can be drawn based on such demand. If it is not on record, we could have the benefit. Point number three, every demand of money is not demand of bribe. Prosecution must prove pendency of work, act on the part of accused, demand of bribe. If all the ingredients are not on the record, then accused could have the benefit. So basically, these are called golden rules. So simply, we could say that if you are going to observe the case, you have to observe that what specifications are on record regarding demand. Regarding this, you may formulate five important points. Number one, who has demanded? Because if demand is not direct, it is through third party, and third party is having no connection with you, then there is a plus point for you. Number two, from whom demand is made is also important, because if the concerned person is not complainant or victim, he is basically a third party highly interested in the case to implicate the public servant. In that scenario, we could have the benefit. And apart from that, we have to observe what work is pending. If the answer is in negative, that no work is pending, then we could have the benefit. And number four, whether any favor had been accorded by accused to complainant or not. If it is not, then we could have the benefit. Last but not least, delay in filing the report. If there is a delay, it is evident and it is unexplained, and apart from that, there is violation of Section 8 PC Act proviso, then we could have the benefit. So basically, we could say that if demand is unclear, unspecific, then we could have the benefit. So specific demand must be on record. As we know that in case of Neeraj Datta versus NCT, judgment date is 15th of December 2022. Honorable Supreme Court observed that if the complainant offer and accused accept the offer voluntarily and it is regarding the bribe, in that scenario, the accused could be prosecuted as per Section 7 of the PC Act. So basically, we may say that mere recovery of money is not enough. Demand is must. If demand fails, the prosecution will fail. So it is called golden rule number 2. Please be noted. So demand is required to be proved by the prosecution regarding that the report, verification report, transcription, audio, statement of complainant, statement of shadow witness, other witnesses are important. If there is inconsistency, lack of corroboration, then we could have the benefit. So if demand is not specific, there is no word, there is mere gesture, then the accused could have the benefit. So simply we could say that the burden is on the prosecution to prove the demand. If demand is not proved and there is no specification regarding the demand, in that scenario the accused could have the benefit. So basically we must read our file in the light of set principles so that we could chalk out a good defense on record. Remember that you are not supposed to give the explanation beyond reasonable doubt. We are supposed to give our explanation on the point of probable defense so that we could be succeeded and could have the effective defense on record. So I think that I have specified you the topic in the easier way. See you in the next lecture.